Good evening, everybody. Good evening. It is Carmella George with you again. I am a VA Accredited Claims Agent, and I do this live monthly to take some of your questions to try to help as many veterans as I can. Tonight, October 6, 2022, I'm so glad to have with me a special guest. A VA claims agent, accredited VA claims agent, Charles Miles is with us. Thank you so much, Charles, for joining us. I think that you're absolutely brilliant, and so I'm thrilled to have you on the show. Go ahead and tell the audience a little bit about yourself, about your history. He has a remarkable history as a veterans advocate and as a veteran himself. And go ahead and tell the audience a little bit about yourself, Charles.
Well, first, thanks for having me on. My name's Charles Miles. I'm a veteran of the 1991 Gulf War, and I got involved with veterans issues back in the early 90s when I ran into a couple guys at the Atlanta VA during a Gulf War Veterans Readjustment Counseling session, and like me, they had some health problems that seemed to be related to the Gulf War. And long story short, I ended up helping to found the National Gulf War Resource Center in Washington, D.C., and spent much of the 90s and early 2000s kind of working around policy issues, lobbying to get the laws changed. Because, at the time, you couldn't go to the VA at all unless you had a service-connected disability, or I think the floor was about $20,000 in income. If you were below that, you could go to the VA. There was no grace period when you got out of the service. It was nothing. And we were really focused on particularly making some changes for veterans exposed to toxic exposures in the Gulf, and chemical weapons and some of the drugs we took, and the vaccines and a lot of the experimental type things that were happening. A lot of people came back sick, and nobody knew why. And that ended up resulting in some of the laws we have now, some of the ones that were passed in the 90s that recognized undiagnosed illnesses and things like that. And so I've been involved in that for years. I just recently, in the last couple of years, started to specifically work around claims. I had some experience working with one of the big DC law firms as their it's kind of head of their outreach to veterans, and it made me realize that I wanted to work claims and help people who'd been, to put it politely, screwed over by the VA. I was one of the people whose my service treatment records got put in the wrong file cabinet and disappeared for 25 years, and obviously that put a halt to my own claim. And when it was found, and when I got it fixed, and when I got it backdated, all those years, it made me realize that there were a lot of people who were probably in the same position I'm in. And so that's how I got into this. And honestly, Carmella, it was your website that got me thinking about applying for claims agent status. So I owe you that. You had a lot of great advice there, and I appreciate it.
Well, thank you. Thank you so much. But you're brilliant all by yourself. And so you definitely are a great agent. I've seen your writing products. I've followed your work, and I'm so glad to have you on. But you forgot one major credential, Mr. Miles. That is the case that went almost all the way to the Supreme Court. Talk about that a little bit.
Sure. That really centered around mental health issues. As I'm sure everyone knows, that the number of suicides of veterans is through the roof. And Veterans for Common Sense, which I serve on the board of directors on, we joined with some other organizations and filed suit with the VA back in 2008. And our goal, and we ended up losing, although we got all the way to the Supreme Court, but our goal was to force VA to make some significant changes. And, the stuff we saw, the stuff we learned in discovery, and the documents that the law firms put together, it's just horrific stuff. Veterans, committing suicide in the parking lots of VA hospitals after being turned away and things like that. I mean, it was just terrible. And our goal was really to make some changes, and we forced some incremental changes from VA during the period as it made its way up through the appeals court and the Supreme Court. They did establish the Veterans Crisis Line. Congress moved to make some changes, and so it's a little bit easier to get healthcare. You don't have to prove a mental health claim as service connected before you can get your first appointment with a mental health care professional for treatment. And that's a huge change, because
That's
for
major.
so long you couldn't get help, and you had to jump through all the hoops and do your 3, 6, 18 months to prove your claim was service connected before you could do anything. And the bottom line is the VA should provide services first, worry about service connection after.
Absolutely. So thank you for your work. Thank you for the work you put in for over 30 years now for veterans, for being a veteran yourself, and for joining us tonight. Mr. Miles is going to help me answer some questions tonight, and we're not going to parlay the matter. We're going to jump right in. So I see you guys have already filled us up with questions, and I try to be as thorough as possible. And so I might not get to as many questions, but I'm going to try to answer, and we're going to try to answer what we do answer very thoroughly to give you the best education and the best direction we can on your claim. Of course, this is not legal advice. This is not medical advice. This is our thoughts on the little information you give us. We have not reviewed your file. If you have a representative yourself already, you should definitely take that representative, their opinion over what we're saying, because we have not reviewed your claim file. And usually the facts of the file give me a very different picture than sometimes what my veterans tell me. And so, I'm just answering that based off the little information you're giving us tonight, and you should take that into consideration when you consider the advice I give. So let's jump right in. You ready, Mr. Miles?
I'm ready.
All right. First question. What are some conditions migraines can be secondary to? My answer to that would be that it's usually what causes your migraines. That's an individualistic situation. You have to be honest about what causes your migraines, and that is what is, if it's service connected, that's what it's secondary to. I frequently, to actually answer your question, I frequently see things like PTSD, sleep apnea, just respiratory conditions and things like that. The headaches can be secondary to allergic rhinitis. But, it's important in the claims process to honestly assess what you think is causing what. So when you're before the examiner, you're authentic. You can really describe what's happening, and there's a clear connection. You have anything to add to that, Mr. Miles?
I usually tell people when they're asking about secondaries and things like that, start with what is happening with you. It's because that's the bottom line. You're aware of what your health conditions are, and some of those relationships may be obvious and some may not. Like Carmella said, I often see migraine secondary to mental health, to stress, to traumatic brain injury. Is a common one, but it's what I usually start with any file I'm reviewing, for example, is I'll literally make a list of every health problem that comes up, every single one, and then try to think about what are the relationships between those. For example, there are some medications that can cause severe headaches, and
Absolutely.
Some of those medications may be prescribed because of another service-connected condition. So you really got to take the whole picture of what your health conditions are.
Absolutely. Okay. Mr. Ham or Ms. Ham, ACE exam through LHI for increase in GERD. I submitted a personal statement listing my symptoms. Will they consider this? They said I might not even get to talk to the doctor. What the heck? And so I'm going to be frank with you that the answer is they should review it. it is lawful that they do review it, but the honest answer is that they might gloss over it. And so you want to do everything that you can in your power to make sure that your file is organized, that you submitted an organized listing for the examiner of evidence that you submitted, and that's properly in the file that it actually reached the VA. But that's about the most you can do. Uh, the guidance provides that examinations are fluid. The examiner can handle it aside from the DBQ basically any way they desire. And so what they review is, a decision they make. They should review the whole file. Some examiners make the mistake of only reviewing medical evidence, and that's a major mistake. They should review medical and lay evidence to form the full picture of the condition that the veteran has. But a lot of examiners only review the medical evidence, and then they write an opinion that says the medical evidence does not say. Well, what about the lay evidence? What about the veteran statement? The subjective part of the nature of the file has to be taken into consideration too. And the Board of Veterans Appeals frequently remands for these reasons. And so the question is, it should, will it? I don't know. Charles?
Yeah, that's a great answer. It's very often the doctors don't look at the lay statements, and that's one of the first things I'll look for if I'm preparing an appeal is, did they do that? Because they're required to. If they didn't address it and you didn't get the answer you were expecting to get, then that is grounds for an appeal, and you can often get a new exam that way.
Right. Very much grounds for an appeal. Okay.
I wish I could say, you could fix it in advance, but that's a tougher nut to crack.
Right. Carmella, I got diagnosed with retinal degeneration yesterday. Doctor says it is most likely systematic from my breast cancer. I have a claim for SMCK. Is there any benefit to filing for another SMC? I also received SMCCS for HB. I'm not sure what that is. Charles, you want to answer that?
Housebound, probably.
Yes.
There is a benefit to filing for SMCK on top of SMCS. So you can have both at the same time. The SMCK is like an additional, it's $113 now, $120 over and above what your other claims are.
That's absolutely correct. And so there is benefit to filing for the extra SMC, and you might want to pursue that. Okay. Good evening from Washington State. Hi, I'm in Mexico as we speak. I'm not sure what state you're in, Charles.
I'm in Western Massachusetts.
Western. Oh, it's cold up there.
It's starting to cool down. It's fall. Yeah. I was just outside putting the chickens to bed. Actually, I had to rush up here to get up here in time.
It's 90 degrees down here, Playa del Carmen. Okay. Hello from Milwaukee, Wisconsin. Hello. And I'm not on vacation. I'm here for a dental procedure, if you can't tell. And so I'm getting that taken care of. Finally, it's been a long road. And so I've been out here a couple of times, and I am happy to have it finished up. How was Guam? Guam was absolutely amazing. I met the most wonderful people. If you've never been to the territory island of Guam, they are some of the most hospitable, nice, just wonderful people that you've ever met. Everybody was welcoming. Even the governor, lieutenant governor, was glad to have me there. And I was so glad to be there. I hope to make a return trip soon to teach a more advanced level class. But there's a major dearth of accredited representatives on the island of Guam. Aside from the state office, there's basically not any. And so I taught 10 more people there the basics of, veterans law and representing veterans and that type of thing. They were so happy and enthusiastic that it made teaching the class easy. And I'm excited to go back and train and teach some more. So Guam was amazing. Thanks for asking. Hi, Carmella and Charles. Thank you for supporting veterans. You're so welcome.
Thank you.
No, you're so nice. Thank you, Carmella George, for all you have done for me. I don't know who this is, but your service is what got you where you are. So give yourself credit too, and I'm so glad I could help. Hello from Baltimore. Wow, it's cold up there too, isn't it? And I left North Carolina, it was cold. Are you accepting new veterans? So I'm currently not. My expected date, because I have dental surgery next week, I had to move it back a week, is October 19th, I believe, when I'll start accepting clients for 2 weeks until November 2nd. But I believe Charles is. And don't get me wrong, he is a great option for representation. So I have a list of referrals on my website of people who are open to taking clients. Charles, are you taking clients?
I am. I'm doing it real slow because honestly, it's important to me to do like a really thorough review. So I try to take my time and just accept, one client at a time. Then I'll open back up and take another client, then another one. But yeah, I'm slowly bringing in new people.
Awesome. And what's your website, Charles?
It's veteransclaimsagent.com. I can
Veterans with the S, claims with the S,
right?
then agent.com.
Yep.
So do look into Charles and his representation if you're interested in somebody currently taking clients. Like I said, I'll be accepting in about 2 weeks. I am working to expand my staffing capacity to be able to accept more clients and accept it on an ongoing basis. But this round I'll be open for 2 weeks, and then I probably won't take clients again until February, March. So yeah, that's where we are with that. Hi, Charles. Thank you for your service and all you do for veterans.
Oh, well, thank you.
Hi, can I collect retirement pension and BTDIU? So I assume that you're talking about military retirement, and the answer is yes. Is that correct, Charles?
Yep. Yeah, the TDIU prevents you from taking gainful employment, but it does not stop you from taking any kind of passive income.
Yeah, that's not earned income. So you did earn the income over so many years, but you know what I mean. Okay. Can I claim SIJ secondary to my left knee? My left knee buckled and I fell down the stairs and bounced down on my buttocks. Oh no, I'm being treated for SI. SI joints, scarlet iron joints. I'm assuming SIJ means, I'm not familiar with the acronym.
Maybe sacroiliac.
Yeah.
I'm actually representing a case right now where that's exactly an issue.
I think that's what they're intending to communicate. Yeah. But yes, I had a client that fell down and broke his knee. He's actually a doctor, physician himself. He fell down and broke his ankle. In the process of falling, he fell on his shoulder. He fell on his knee, and all that got service connected as a result of the fall. So yes, if your knee buckled and it caused some other injuries and your knee is service connected, then the other injuries can be service connected. You just clearly need to explain that in your claim. You either need to write it out, SI joints secondary to fall because my left knee buckled. That could be the exact claim, or you need to submit a personal statement that makes it clear that you fell downstairs because of your knee, and claim everything that is afflicting you because of that.
Yeah, personal statements can go a long way, and they're supposed to accept those as, unless they find like specific evidence that says that your claim is not credible. They're supposed to accept your personal statement as the truth.
Right, at face value. Hey, Doug. Howdy, y'all from Connecticut.
Yeah, it's right down the road from me.
The man, Doug Hayes, right there. Taught me a lot when I was just getting into this. Baltimore here, another veteran from B More. Hello from South Carolina. That's my peoples in the Carolinas. We share the Panthers. I have a CIDP neurology, very rare. Oh wow. I don't see the question there, but I will be praying that that gets better. That's what's happening to my husband now. 2 years waiting on in service medical records. Any advice there, Charles?
I know I see a lot of people posting that they've been waiting to file their claim until they get their records from the National Archives and that they're waiting years. If that's the case in your case, don't wait to file your claim, because VA will get your records in a few weeks versus you taking a couple of years. It's literally quicker to file your claim, have VA request them, VA gets them, then you file a C-file request from VA and get your records than it is to get them from the archives. It's crazy how long it takes.
Yeah, that's absolutely true. As a matter of fact, it might not even take weeks. VA can get them in a matter of days. I mean, they have that kind of strength and muscle power. And so do not wait on to collect your records yourself to file your claims. File your claims and let the VA get the service treatment records. They can get your VA treatment records too.
Right. It's not uncommon that, VA's already got them, particularly if you got out of the military sometime between 92 to 98 and after, then your records are probably already at the VA Records Management Center and they're not at the archives in the first place.
Right. I think 92 is when they started digitizing records instead of the handwritten records for the most part. Good evening. I guess my husband's got misplaced as well. Wow. A lot of misplaced records tonight. That's unfortunate. Hello from San Diego, California. Hello. Mississippi. We're down in the South. Wangram, North Carolina. Never heard of that. And I'm from North Carolina. Y'all know that. My Camp Lejeune. Hello, Kentucky, from Kentucky. Hi. VA needs to hire and train more raters. I would especially agree with this, especially the training part.
Especially the training. I was thinking the same thing.
Frequently, especially if you look at recent Supreme Court arguments in veterans benefit cases, you will see that the VA makes the wrong decision the first time a lot of times. And so I think there is room for better training and more training. I don't get every case perfect or right, but I try to be knowledgeable in what I do. I try to be good at what I do. And there's not enough of that at the VA. There's, in my opinion, there's not enough of a thirst for knowledge of veterans law. It's more of just it seems like to me, a government job and security. And so there's got to be more of, we want to get it right for the veteran the first time. That would save so many years of appeal at the Board of Veterans Appeals, save so many years if you have to go to court or a higher level. And that's just Carmella's take.
I agree 100%. The other thing with the VA too is that they're under all kinds of time pressure and quota pressure to like move through those cases really quick. And I'll tell people all the time, make it easy for the rater, get it as organized as possible. Don't send in 10,000 pages of medical records, send in the 50 pages that really count to prove your case.
Right. That deal with a specific condition. That's excellent advice. I always tell my clients to please send me your medical records first so I can pare them down to what's needed. Because just sending everything the VA's way is in my opinion, not the best strategy. There could be records in the records that are detrimental to you, and you probably want to leave those out. The law says nothing about presenting negative evidence against yourself. And so you want to make the best case, present what's necessary, leave everything unnecessary out. Charles makes a great point there. Hello from Maryland. Can you file a claim if you don't have your medical records and you got out in 1985? That's when I was born. Absolutely. Absolutely, you can.
Right. Because the first thing that will happen when you file your claim is the VA is going to they're going to ask you for your DD-214 and your some indication, some proof of that you have a condition now, but then they're going to go and request your service treatment records. And so if you got out in 85, your service treatment records are at the National Archives, or should be. I shouldn't say are, because who knows, but they'll request them from there, and then they'll have a copy of your service medical records.
Right. Okay. Here we go. If I filed a claim, then a few weeks later filed an intent to file, will it backdate to my intent to file if my initial claim is denied? If I get more evidence and submit again with that intent to file, the answer to that question would be yes. Or if you file a supplemental claim on the denial, it should go back to the file date even earlier. I'm wrong. Because if it's continuously pursued, you should hold the date under AMA, under the Appeals Modernization Act, should hold from the initial date of the claim. So as long as you file a claim within 365 days of that denial, it should go back to the original filing date, not the intent to file date. Anything to add there, Charles?
Yeah, no, that's exactly right.
I filed in July of this year, and I'm sitting in evidence gathering, still no CMP exams. They told me my file is in a national hold in place for any VA to pick up. So where your file is at is called the National Work Queue. And it needs to it sounds like it needs to be distributed and assigned to somebody, to a VSR to take action on. This is not an uncommon place, but it's an abnormal time frame for it to be sitting there that long.
Yeah.
That was July. It's now July, August, September, October, 4 months. And so if I were you, I might set up a call with VERA, Veterans Electronic Reporting Application, or whatever it is, the new way to contact regional offices, and just try to gather some more intel on why it's still sitting there and ask them to assign it to somebody. I think that VERA is a better resource than the 800 number, National Call Center, but that's just Carmella's take. And so I would do anything, to try to get action and get that file moving, because that's been there sitting in evidence gathering for too long with no exam scheduled.
Yeah, I'm surprised that you haven't had any exams, because often the exams will come really quick after you file a claim, and then you sit and wait for several months. But yeah, that raises some red flags for me. And I what it might be is they initially looked at your claim and didn't see something that they were expecting to see. So I would definitely see if you can get a look at what the status is. I think VERA is a great option if they're.
Yeah, I will say this. What I've been telling my clients is, because it's true, is that the system is kind of constipated because of the PACT Act right now. And, to be blunt, until they let it out and dispose of the waste, it's moving just a little bit slower. What I'm seeing, I got lots of decisions today. I actually got 500%. But what I've been seeing for the last month or so is that there's been a lot of moving claims to exams that have been filed, but not a lot of decisions being made. And so until they get a grasp on it, what is true is that October 1st started a new fiscal year. That usually allows the VA to do some more hiring, which means more errors up front, but that's neither here nor there. It allows the VA to do some more hiring and bring on additional staff and fill vacancies. And so things might start moving again. But, in August, the VA got more claims than they ever got in history. That's what the VA secretary stated on Twitter. And because of that, I think things have been kind of constipated and moving slow. But we shall, hopefully with this new fiscal year, we see some more things moving. Yeah. Hello from Aurora, Colorado. I've never been there. I did just visit Colorado for the first time in Denver, but I was just passing through on the way from Guam. Hard to breathe there. All righty. Mental health CMP on January 6, 22 has 50% block checked. Went in for increase on July 22nd, 22, has 30% block check, but examiner changing diagnosis from adjustment disorder to PTSD. Will rating decrease with 30% block check? This is an interesting question. Charles, you want to take that one?
Yeah, it's without seeing your file, it's really hard to answer. They could propose a decrease. You would then have a due process to show evidence that decrease is unwarranted. The key thing there is, your any treatment records you've got. Are you taking prescriptions? Because sometimes the examiner will be asking you your symptoms today, and you're taking antidepressants today, and you're feeling okay. But they're supposed to rate you based on your symptoms unmedicated. And so the raters are supposed to look at the whole picture, including all of your treatment records. If you're not getting treated at the VA and you're getting private treatment somewhere and you haven't sent in those records, I would do it based on what you're saying here, just to make sure that they've got that whole picture. But if you're being treated at the VA for your mental health claim, then they should have those records available.
Right. And I would add that, Mr. Chris, for mental health, what matters, not just the box under social and occupational matters in the rating. The list of symptoms on the second to last page, I believe, of the mental health DBQ also come into play in the rating. So if there is lots of those boxes checked, it could still raise your rating to 50%. What happens is a rater plugs what boxes are checked into a rating calculator in the system, and that kind of tells them, or it doesn't make the decision for them, but it gives them an automated answer of what the suggested rating is. And so if more of those boxes of symptoms are checked at the end of the DBQ, then it might just raise it to 50. So you either have to, assess that for yourself, have your representative assess it, or wait for the rating. Okay. If I was denied a sleep apnea claim in 2012, what would be the best way to appeal it? HLR, appeal, or supplemental? If awarded, would it be backdated to 2012? Mr. Charles?
Supplemental is your only option because HLR has to be within the last year, and an appeal to the board, it's the same. Where there's narrow circumstances where it could be backdated, but it's very narrow. So if you're looking to get it service connected now, then you would need new and relevant evidence for a supplemental claim.
Right. So those rare circumstances that Charles is referring to would be something like a clear and unmistakable error. This is where you might want to get a good representative to review your file to see if there's anything like that. But those circumstances are rare, just like he said. And so you would have to file a supplemental. You don't have the other options because it's been longer than a year. And you have to present new and relevant evidence with that supplemental. And so just be aware of that, or it's going to be rejected.
Mm-hmm. And understand that new and relevant evidence for supplemental could be buddy statements from people you served with. For instance, if you served with people and they reported that you snored all the time and you got kicked out of the barracks, or things like that, that would be an example of relevant evidence. That so it doesn't have to necessarily be you suddenly discovered unknown records. And if records reappeared, for instance, you went to sick call for sleep apnea or for snoring or constant fatigue or things like that while you're on active duty, and VA didn't have those records in 2012, then that would be one of those cases where you might potentially be looking at a back award. But the back awards under those circumstances are pretty narrow. So
right. And new and relevant tends to mean evidence that proves or disproves a matter at issue in the claim. So that's how it's frequently explained to veterans. You just need to prove or disprove some issue, any issue in the claim that's relevant to the claim, and be aware of that. Like Charles said, a buddy statement would do it. that talks about some history that wasn't there or something like that. Or there's lots of other forms of evidence, photographic evidence, uh, medical evidence, that you could gather and use if you have it. And so just be aware of all the avenues that you could take to get that reopened.
Mm-hmm. And it's important to look at your original rating decision too, and really understand why they denied you. Because, right. For instance, if you were denied because of a lack of current diagnosis, then it won't do you any good to present data from when you were in the military, because the reason why is because of the current condition. Or if you were denied because it wasn't reported in the military, then you could send them all the medical evidence in the world that you have sleep apnea today. And that's not going to help. You need to address what was the specific thing that was in the denial.
Absolutely. Okay, here we go. Good evening. Big thank you. How about my claim where the nexus was viewed as not sufficient since I was not seen in person? Please explain to folks how to prevent this. It has been a nightmare for me. Carmella, not sure who this is, but I probably do know. And if a nexus was denied because you weren't seen in person, then one avenue that you could take, there's a couple different things you could do. But, off the little information you've given me, that a HLR might be appropriate. And then explaining the manual guidance and the law that nothing says that you have to be seen in person for a nexus to be sufficient. Like you have to, unless it's like a joint condition or something. But we're talking about a nexus, not a DBQ. So they could, a nexus writer or examiner or provider could just do a records review, which is like an ACE exam that the VA does every day, and the nexus would be sufficient. And so you just sort of have to make that comparison for the higher level reviewer and get it straightened out. But that should not have been the reason that the nexus wasn't viewed as sufficient. That's BS in my opinion. Charles, anything to add there?
Yeah, agreed. That's VA schedules exams via telehealth all the time, and ACE exams where there's no meeting, meeting with the veteran at all. That they make those determinations based on the records, and I think that's good grounds for a HLR. What I would suggest, if you haven't gotten it, is get a copy of the actual exam that VA used, because it's entirely possible, and this happens all the time. You'll send in a 10-page detailed nexus letter citing all kinds of research, and then the VA examiner writes a 1-paragraph response that doesn't even address any of the things in your original nexus letter, and that's a pretty easy appeal to at least get a new exam. And so it's really worth getting a copy of the exam if you don't have it.
Charles is absolutely correct. And it boils my blood, literally. Like, I love this work. I love this. I have a passion for it. It boils my blood when I see the same statements, specifically out of LHI, that says this condition is separate from this condition and it's not medically related. That's all they say. They don't even mention the actual conditions that you claim. And so it's just a generic boilerplate type template statement that they're copying and pasting from somewhere, and they haven't really given your claim the time of day. I would fight that to no end, because medical opinion should be specific. It should be relevant to the conditions that you claim. That generic boilerplate type language that doesn't mention anything you claimed or mention you or your how it affects you is not adequate. It's an inadequate medical opinion, and you need to fight it. Thanks for doing this. You're so welcome. You're so welcome. My pleasure. If you have medical conditions listed that say not service connected, how do you get them, or can you get them service connected? Knee pain, ankle pain, etc. Charles?
Well, the reason what you got to look at is why did they say it was not service connected? Because not service connected is the conclusion, but it's not the reason. So the reason is going to be you're missing one of three things. You didn't have an event in service, or you don't have a current diagnosis, or you don't have a nexus between them, or some combination of those. You need one. You need those three things to get service connected. And so look at your rating decision that you got from VA, and it'll spell out why, unless it's a really old rating decision. Sometimes those don't, but certainly all of the newer ones will say exactly why, and then you can attack the specific reason why they denied it.
Awesome. So I see. Let's see what we got next. Okay. What can you tell me about the new part of the caregiver assistance program that started on October 1st, 2022? Basically, from my understanding, the caregiver program is a VHA benefit, Veterans Health Administration benefit. So I don't necessarily deal with that as a claims agent because I represent veterans on the Veterans Benefit Administration side, the claims part of it. But I can tell you that the caregiver program, assistance program, opened to all areas of veterans on October 1st. And that's basically the new part of the program, is that all areas of veterans are eligible now for caregiver assistance. Charles, you know anything else about that?
Just a little. The caregiver assistance is awarded if you have difficulty completing. I think it's like 2 or more activities of daily living. So it's if there's certain things you can't do without assistance, like getting dressed or taking a bath or things like that. And I forget the exact list. This is outside my area of real expertise. But if you get denied, it's coming from the medical side. So someone in VHA is doing that. You do have the option to appeal to VBA now, but it's not really been something that I've been, or rather, you've got the option to appeal to the board. But it's honestly, that's well outside my area of expertise, other than that little bit.
Mine too. And I will say, I will add this. The program is kind of a mess right now. Like even though they open it to new areas, they don't have it figured out. I mean, they've gone back to the drawing board a number of times now because of complaints and other things like that, and people being frequently dropped from the program. That's about all I know. I just know that it's not the most well put together program right now, and there's still a lot of work to be done on it. So be mindful of that when you apply, when you're dealing with it. That I think they've halted kicking people out of the program for a few years. That was announced today, but it's still a fluid type developing program, and y'all should be aware of that when you're applying. Now, it's not the type. I'll put it like this: it's not the type of assistance that I would get used to and count on every month for forever. So, like service connection, which can be reduced too. So I guess that's not forever. Okay. Is it normal to have a sleep apnea CMP and the doctor is in another state and does not even call you and ask you any questions? And I did not have to do a DBQ. Yes, it's normal. It's called an ACE exam. It is allowable. Is it the best way to examine a veteran? No. Some ACE examiners will call the veteran to ask questions. Some of them will just do a records review. So, is it the best method of examination? I don't think so. That's my opinion, but it can be done. It's just like a Nexus provider who just reviews your records and renders an opinion. It is a valid way of examination.
Yeah. The key thing there is when you file your claim, make sure you've got written statements detailing everything that you would say to the doctor, because the ACE exams do happen, particularly where, at least where I'm seeing them happen, is in appeals. We get a bad exam initially, appeal it, and then they do an ACE exam, and that might be a bad exam too. So it's really important to get the details in writing.
This is a good question here. Do I need an independent medical opinion or nexus to file for tinnitus? I have been diagnosed with tinnitus by my VA doctor, and I am a Gulf War veteran. So the answer to this is no. You don't need an independent medical opinion or nexus to file any claim. You can
Right.
file a claim, but the question becomes, what gives your claim the best chance? What evidence can I provide that would cause the VA or the VA examiner to rule in my favor or render an opinion in my favor? And sometimes an independent medical opinion or nexus will do that. Now, there's a lot of times where you'll get a CMP exam, which is a free way to go about it. And especially if you have a current diagnosis, and you you're on the noise hazard type, what do they call it? The had an MOS that had some level of noise exposure.
I just downloaded that spreadsheet today, actually. It's the,
Yeah. He's
what is it
fine,
called?
but it would be helpful. There's times when it's not needed, that you will get the free CMP exam. They will run an opinion in your favor, and you'll get service connected. So, is it absolutely necessary? No. You have to decide whether it's helpful for your individual case.
Mm-hmm.
Okay, here we go. What happens when they do that, Carmella? Not consider the whole claim. When they do that and you get denied because of it, you need to fight it. Sometimes a higher level review is a good situation for that. Sometimes the board is the best situation for that. A good representative will help you delineate which route you need to take for appeal, or you can file a supplemental with more evidence and overcome that sometimes. And so a good representative will help you delineate which route is best for your claim. A lot of this is individualistic, and it's based on the individual facts of the file. So if they did not consider the whole claim, the question becomes, what can you do to highlight the record or represent new and relevant evidence that will move the person's reviewing the file to see your claim in the whole light, in the fullness of what you present. And so sometimes that is simply submitting an organized claim. Sometimes it's where you sent in 100 pages of medical records where you only need to send in 15. Sometimes it's adding a statement on top of things that connects the dots for the rater. And so when they don't consider the whole claim, you need to do something to have them consider the whole claim. Charles?
Yeah, that's exactly it. Particularly, in some ways, even though it's not supposed to be, this is not all that different from dealing with the courts, where like written documents have that they've got a huge advantage, and so that's a case where you want to assess how you are presenting it, and if it's organized and easy to read. Get other people to read it, to see if what you're writing makes sense. It's really, you got to make your case.
Right. So we got a statement here that says tinnitus is presumptive. I got 10%. That would be incorrect. Tinnitus is not presumptive on any list for any era veteran. It has to be proven. So,
you're more likely to get it if you are in a MOS that had noise exposure, and VA maintains like a spreadsheet of all of the MOSs that let me rephrase that. They maintain a spreadsheet of MOSs that have that. I've found some holes in it, people who had like a specific MOS that's just not listed in there. And so I've had to reference comparable ones, like if somebody was a field radio technician in the Marine Corps, well, that's comparable to communications, and that was a noise exposure thing, even though I don't see it on the spreadsheet.
Right. Say for instance, you were a supply chain specialist, which I think rates low probability noise exposure. What I'm saying, you would want to, if this was true for you, you would want to highlight the airplanes you worked around, or the grenades you threw, or all the gunfire you might have been around. You want to submit a statement that talks about the noise exposure that you did experience if you're on that low probability list, because otherwise they're going to assume that you had, you're around little noise. And so you have to relevant to your claim for the reviewers.
Mm-hmm.
That's always helpful. Can the benefit of doubt doctrine be used in an HLR to weight a CMP DBQ and a DBQ submitted by a private physician to grant higher award between the two? Charles?
That's a great question.
Yeah.
The benefit of the doubt would weigh if the VA opinion and the private opinion were of equal weight, and VA has this whole this whole thing they call probative value, which basically is a subjective value where they're looking at it and they're saying, well, this medical opinion is more convincing than that medical opinion. And it's not a medical professional who's making that assessment. It's a rater. And so they do have some guidelines, but honestly, they land on the VA doctor being more convincing than the private doctor 99% of the time. And so I rarely, hit on the benefit of the doubt doctrine. I usually actively attack the VA opinion if it's wrong by looking for things that are wrong, the overlooked evidence or facts that are incorrect or reasoning that doesn't make any sense.
Right. And Charles is absolutely right. Is that a lot of times the private physician opinion and DBQ is more thorough and actually interviewed you, where sometimes the CMP examiner, just because of time constraints and other things, they don't do the most thorough job. But a better law to use or doctrine to use in the benefit of the doubt would be the law that says where there is a question of which two ratings to apply, the higher rating should be applied between two DBQs. And that's the law is pretty straightforward with that. It gives a little wiggle room where there's a question of two ratings, possible ratings on a claim, the higher should prevail. And that would be, a better argument and a higher level review. You could use both arguments, but what might be most appropriate is to hire the two ratings law. I was 100% rating reduced to 90. Oh no. What do I need to do to get back to 100%? I would say fight the reduction, number one. Why was it reduced? I find, this is Carmella's statistic. About 80% of reductions are improper. They either forget due process, what's the other arguments I make on reductions? They forget due process, they they don't consider the whole recorded history. They frequently use exams that aren't as thorough, or don't consider all your symptoms or your lay statements and things like that. But a lot of reductions, I find that the overwhelming majority of them I can overcome. The most appropriate route would be to ask for. Well, this is up to you. But what you can do, a possible method is to ask for a hearing within 30 days of the reduction. The law provides every veteran that opportunity. And that requesting a hearing, a personal hearing, will delay the reduction until you get that hearing. A lot of times hearings take 3 to 6 months to get. And in that time frame, you can gather new evidence, either present it to the VA before the hearing or during the hearing, and that will allow you to keep the rating that you had. And so that is one strategy, is to request a hearing on a reduction immediately as soon as you get the notice in the mail, as soon as your representative sees it. Because hearings take time to get, you can gather more evidence and submit that, and that will delay the hearing. Or so another method sometimes I use is just to, while the hearing is pending, to request a new CMP exam, to put in for another increase. And that will get you a new exam. A lot of vendors
Right.
don't consider that. So don't just wait for the reduction to be implemented. Actively take action to stop the reduction or halt the reduction or put the reduction off. Charles?
Right. And if you're past the if you're past that deadline and it's already been reduced, but you're still within a year of the final rating decision, you're still within your appeal time frame too. You can appeal that just like in the other decision. And then if you're past that year, then you'd have to apply for an increase as if just any other increase claim. One thing I would keep in mind, and this just it sticks out at me because you mentioned 100% and 90%. So you mentioned your overall rating, but it's important to focus in on the exact condition they reduced. And sometimes I'll see people presenting kind of the whole case of their entire disability picture, and so they'll talk about their arms and their legs and their PTSD, and then it's all together. And when they're rating a condition, when they're doing a reduction or an increase or whatever, they're looking at one condition at a time and only that condition. And so unless you're speaking specifically to that one thing that got reduced, then it's kind of generating extra work for the rater and making it harder for them to understand your case. So you want to focus as narrowly as you can.
Absolutely. Okay, here we go. I'm at 100%. Had a pending sleep apnea, obstructive sleep apnea, which was submitted as secondary to mental health. Received service connection of 0%. The decision statement says 50% was awarded to CPAP usage. No one at the VA could explain why. So there's a method of rating a claim. I believe it's called Allen aggravation type rating, where if you had the condition prior to it being aggravated by the intervening condition, which would be your mental health, they will take the level of percentage that your pre-existing condition would have been rated at. They will take the final percentage away from the pre-existing percentage, and that will leave it sounds like what you were rated at 0%. It sounds like your sleep apnea was obstructive and you had a CPAP before the mental health condition, and that would have been rated at 50%. But it sounds like the mental health might have aggravated it. And then, at the end of the day, you were still using the CPAP and that was rated 50%. So they took 50 away from 50, leaving you with 0. Now, there are times when the VA gets Allen aggravation wrong. The calculation. There are times when you should still be rated 50. And so you need to examine that closely or have somebody with aptitude to examine that closely and make sure the VA rated that the right way. Because sometimes there's 2 types of aggravation and sometimes the VA gets them mixed up. Charles?
Right. Yeah, I was going to say that essentially the same thing. I would definitely want to take a hard look at this and kind of see why, particularly because the burden on VA to determine what, like in an aggravation case of, how serious was it before it was aggravated, they've got a pretty high burden to prove that was there. It would have to be noted on your entrance exams or in some other way. And I'm going to give you a personal case. Like I had documented records when I enlisted in the military of a significant period of depression when I was in high school, and it was right there in the records. But I was awarded PTSD with depression anyway. And that was not reduced, and it was because of that the presumption of wholeness at the point I went in. So they really have a high bar, and they don't meet it most of the time. And so that is an appealable issue if it is an aggravation award. The other possibility is they just messed up in terms of how it was calculated. That's not often because those calculations are generally done through an automated system. What else could it be? Those are the only two things that come to mind.
Charles talks about the presumption of soundness. That's a very powerful presumption. If it's not marked on your entrance exam, or demonstrated, beyond the clear and unmistakable error to some other degree, they cannot presume that you have the condition. And so this is where a lot of times, especially with mental health exams, I see this is a tangent, but a mental health exams I see when they talk about things in your childhood and they try to use that against you. If it's not marked on your entrance exam or demonstrated beyond clear and unmistakable error to some degree, otherwise, that they can't use that against you, psychologists. And so, if you just need to make sure they're not trying to use things that the law provides that they can't use against you. Would you submit a claim for toxic exposure of any base? I see a lot of bases with PFAS exposure on the internet from reputable sources, but they are not getting attention like Camp Lejeune. I'll say this. The things that are written in the law as presumptive are, still don't make the easiest claim, but they make it easier. If I know a lot of people talk about Fort McClellan, they talk about some site Fort Ord, and other things. Those are just difficult claims, to be honest with you, because they don't have the presumption. Because I don't know whether there's not enough scientific evidence, or Congress is not paying attention to the evidence that is there, or it just hasn't received enough advocacy. For some reason, they're not presumptive. And that makes for a lot of times, at least the frontline rater will say, it's not presumptive. And a subject matter expert or a examiner will say there's no connection based on what the VA provides is presumptive. And so it's just difficult. It's more difficult and presents a more difficult case. What you want to explore is if any of those conditions that come from exposure or anything like that can be secondary to what you already have, or there's an easier route for you to get that service connected. That might be a better option, but it's not always possible. So, you just have to get somebody to review your file that has knowledge of the issues and every possible way of service connection, and will, give you the best route. Sometimes the next letter, independent medical opinion, will do it. Not always. It really comes down to the examiner and who's the rater that's reviewing your file. So
yeah, they're harder. It's not impossible though. I mean, what I would look for in a case like that is, particularly is their document, like how solid is the evidence of exposure in it, and because the way a lot of exposure presumptions work is they're based on the fact that it's impossible to tell after the fact who was exposed, who wasn't. So, take burn pits or chemical weapons exposure in the Gulf War. We blew up some Iraqi ammo dumps that contained chemical weapons, and nobody knows who was exposed. There's some computer models, but the Pentagon's computer models disagree with the CIA computer models, and they lied about it for 10 or 15 years anyway. And so it was just, who knows? And so the law that was passed to create presumptions for undiagnosed illnesses was kind of extended the benefit of the doubt doctrine, in that since we have no way of knowing who was exposed, who wasn't, then it was as likely as not. And so that's what they've done with Camp Lejeune, is they've basically said that if you were there, then they presume you were exposed to this stuff. But that doesn't stop you from proving that you were individually exposed. But that can be a real challenge, because you'd essentially have to show, for example, if there's a document that says a particular building on base had some chemical exposure, or then you would want to come up with some way of showing that you were there. And that could be buddy statements, and it could be, old diary entries, or a photo of you hanging out with your buddies in that building. and that's it's a lot more difficult to prove those claims, but they are possible.
Right. And I will also say that a lot of times as you get to a higher level of review are the Board of Veterans Appeals, or the Court of Veterans Appeals, it becomes your chances become greater that the condition will get a more favorable look than at the first level of rating. I will say don't give up after being denied the first time. You can submit a supplemental, you can submit an HLR, you can submit a board appeal. You can go all the way up to the court, and sometimes you will get a fairer shake at a higher level review. I believe something like over 70% of claims from the public statistics available from the VA, 70% of claims get either a grant or a remand at the Board of Veterans Appeals. You have a greater likelihood of a favorable decision at higher levels of review, where the actual judge and a lawyer are looking at your case. And so, sometimes it's good to appeal to a higher level. Sometimes it's good to submit a supplemental. You have to, get an advocate and make that decision based on the individual facts of your case. But with things that are toxic but not necessarily presumptive, just because they say no once doesn't mean it's going to be a no forever. And so always consider an appeal route that's best for your case. Good evening, Carmella. I put in an appeal like you told me to for sleep apnea and was turned down. Oh no. I have PTSD and it's been known you also cause sleep apnea. What's my next step? I'm getting very tired of the VA picking and choosing what they approve. I'm sorry that my advice didn't work, number one. And what is true is that the VA just by law gets to pick and choose. And so that's something that every veteran has to deal with. But if you believe there's a secondary method of service connection that might better fit your case, that might be a good avenue for you, I would tell you to get an advocate, possibly if you're not knowledgeable on it yourself, and have them review the facts of your file and give you individual specific advice. But that might be the next best move, is to find a good advocate. But otherwise, you have to make that get your C file, look at the facts, make the decision for yourself of what's the next best move. Because I don't have all the facts of your file unless you're my client, and I could have given you advice just based off what you said, not as tailored to you. Anything you want to add there, Charles?
Yeah, it's hard. There's not enough information here to give like really solid advice, because it partly depends on what type of appeal. If you had filed a supplemental claim and you think you have a good case for an HLR, you could do that. But I would want to really look at the facts of the case first, because you don't want to file a HLR blind without an argument, because 90% of them lose in cases like that. You really want to have kind of solid information there. I will say, like, the VA doesn't like to service connect sleep apnea secondary to mental health. It's doable, but it's not. It's becoming less and less common. So when you're filing that, you want to have good solid evidence. There's a lot of research available out there showing that there are relationships between mental health and sleep apnea. And so, pull down that research, go to Google, get the studies, really make sure you've got all the facts you can. If you did not have a nexus opinion and the VA had a strong opinion against you, then that's gonna make it more difficult. And so you really need to have as all the facts you can get. So like Carmella said, get your C file, find out what's in there.
Right. And I didn't even realize we've been here over an hour already. So we're just going to take a couple more questions. Sorry, we can't get to everyone tonight, but hopefully we'll answer what we did answer very thoroughly. So I'm going to take about 2 more questions and then we're going to call it a night. But thank you all for joining us. Always a pleasure. Mr. Patton, how do I file a claim for conditions that are tied to active duty, but no treatment while in service? Plantar fasciitis, TSD, D diff, the back, I'm assuming our neck, or it could be knee or, but currently diagnosed and being treated at the VA. Charles?
Oh, I mean, any VA claim, you need the 3 things I talked about. You need your current condition, which you've noted you have a current diagnosis and treated at the VA. You need an event in service, and you need the nexus between them. So if you weren't treated in service, that's not a bar, but you'll need to identify evidence that shows that at least started in service. So in the case of PTSD, you would need to be able to describe what events in service caused the PTSD, traumatic events of whatever kind. For degenerative disc, then I would focus on did you have any accidents in service? If you were in an MOS where it was consistent with your service that you were doing certain things, jumping out of airplanes, whatever that could cause specific types of injuries, then that would be consistent. If you had a car accident while you were in the military, those types of things that even if you never went to the doctor, if there's documented evidence that it took place, then that goes to your case. And that documented evidence doesn't necessarily mean it's in your service record. I have filed claims for a traumatic brain injury where someone had a photograph of a bandage on their head while they were sitting on their tank, people who got statements from friends. And another key piece is if you were deployed in a combat zone, then if the events you describe in your statement are consistent with what happened in service, then they are expected to consider that, unless it's just incredible. So, right. And so that's one of the unusual kind of carve outs for combat veterans on VA claims is specific to the assumption that since people didn't necessarily make it back to the rear to do anything, keep that in mind.
Yeah, we all know in the theater sometimes things don't get written down, sometimes things don't get transcribed, medical records aren't created, and so it's important to submit statements, to submit buddy statements of things that happen that might not be of record. But the law provides that when conditions are, especially in combat zones, are consistent with the circumstances and conditions of your service, that needs to be considered too. And so it's important that you provide the framework or the description of the circumstances and conditions of your service that cause or led to these conditions. Make that very clear for the reviewers, and you will have a better chance of getting things that are undocumented service connected. Last question. I had a claim for CIDP, had a nexus letter, and they never looked at it. Okay. I'm unfamiliar with CIDP is, but
it's a neurological condition, right?
Neurological. Okay. But is the nexus letter listed in the evidence section of the letter, the rating decision? Because if it is, then it's assumed that it was looked at. And it's hard to argue that it was overlooked. But if it's not, that provides a gateway of appeal to say that, my letter's not listed in the evidence. The letter I submitted is not listed in the evidence section. My private evidence wasn't considered. And you really need to consider it to make an accurate decision. And, that one might be one method of appeal. Charles?
Yeah, the other thing I'd look at too is even if it's listed in the evidence section, I want to look and see if it was mentioned in the VA's exam, because their examiners are expected to look at any conflicting medical evidence and address it. And if they ignored it, didn't address it, then I would file a HLR.
Right. That's absolutely correct. So thank you all for joining us. Thank you so much, Charles, for being with me tonight. You've been a pleasure. You've been great. Your answers have been accurate.
Thank you.
And just if you would give the viewers a method of contacting you, the best way to contact you or get in touch with you or reach out to you, that would be awesome.
Yeah, it's my website, Veterans Claims. That's both are plural with S's. VeteransClaimsAgent.com, or I do have a Facebook page, Charles Miles, VA Accredited Claims Agent. Either of those are ways to get a hold of me. And I have an 800 number, which I can't remember at the top of my head. I got to memorize that, but I'm too many working claims. Give me a second. I'll tell you what it is. It's 800-898-1043. I don't typically answer that line, but leave a message for me and I'll get back with you.
Awesome. So Charles is accepting clients, as he has room. Reach out to Charles if you need representation. I'll be probably open back up for clients in a couple of weeks if my dental surgery goes all well and I'm feeling better. But I did want to acknowledge before I close, donation from Antoinette Baker. Thank you so much. That does not go in my pocket. It all goes to help these broadcasts keep continuing because it costs money every month. It costs money for the platform I host this on. It costs money for the website. It costs money for this and that and that. Everything costs money, as y'all know. So thank you so much for your donation to help, us reach as many veterans as possible. That's basically the only one I see. So thank you so much, Ms. Baker. And thank you again, Charles, for joining us tonight. I'm Carmella George. This is Charles Miles. We're both VA Accredited Claims Agents. Happy and just overjoyed to be able to serve veterans in the capacity that we do. And thank you all for joining us tonight. Y'all take care.
Thanks for having me on, Carmella.
Yes, sir.